The Alliance is the national peak body for mental health consumers, including people with psychosocial disability, and it is led entirely by people with lived experience of mental health challenges. Through a federation of state and territory consumer peak bodies, we bring forward the voices and experiences of mental health consumers from communities across Australia directly into national policy discussions. At the outset, I want to be clear. The Alliance supports a sustainable NDIS. We recognise the government's responsibility to ensure the scheme remains viable for future generations. However, sustainability cannot be achieved by weakening rights, restricting access, or shifting responsibility onto people with disability, their families, and already overstretched service systems. When people with psychosocial disability lose supports, their needs do not disappear. The cost of support is simply transferred elsewhere to emergency departments, acute mental health services, homelessness services, carers and families. Reducing access to the NDIS for people with psychosocial disability does not remove costs. It simply shifts them. Our concerns remain about the requirement for people to undertake all appropriate treatment before their functional needs can be considered permanent, despite the amendments specifically excluding restrictive practices. We have two key points to make here. First, there is no nationally agreed definition of chemical restraint across the country, nor is there any national legislation covering chemical restraint in the mental health sector. Without an agreed definition, no national data about chemical restraint can be collected, and so mental health institutions are not being held to account. This means consumers continue to experience medication being administered against their wishes under the false justification that it is being provided for therapeutic purposes. Not having a nationally agreed definition creates a risk of inconsistent interpretation and decision-making. Second, we are particularly concerned that intensive psychiatric interventions such as electroconvulsive therapy or ECT could potentially be viewed as evidence of appropriate treatment that a person should pursue before they can access disability supports. ECT is a publicly available treatment funded through Medicare and recognised in some jurisdictions as a treatment option for certain mental health challenges. ECT also causes harm to many people, such as memory loss. The legislation should make it clear that access to the NDIS cannot be contingent on a person accepting a particular medical intervention. Stronger safeguards are needed around the interpretation of the terms appropriate treatment and chemical restraint. Finally, the bill assumes that alternative supports exist outside the NDIS for people with psychosocial disability who lose access to the NDIS. In many cases, they do not. We know from the government's Unmet Needs report that around 500,000 people with psychosocial disability do not receive supports because these supports do not exist. We understand that reform is necessary to ensure the NDIS remains both financially sustainable while continuing to support people with disability. However, reform must not come at the expense of choice, dignity, personal autonomy, and access to the services and supports that people living with psychosocial disability rely on to participate in their communities and live a good life. We urge the committee to ensure that any reforms preserve the rights-based foundations of the NDIS and protect the autonomy and support needs of people with psychosocial disability. Thank you, and we look forward to answering your questions.
Thank you very much, Ms Brice, and I will start with Senator Steele-John.
Thank you very much for your evidence, Ms Brice. Can I just take you to the concerns you just shared about electroshock therapy and your interpretation of the legislation in relation to whether it could be something that is required of a participant. Let me reframe that because it's a slightly complicated way of saying. Just to clarify, from your reading of the legislation, is it possible that a government, this government or a future government, may require a participant to undertake electroshock therapy before being eligible for the NDIS?
Thank you for the question, Senator. Yes, that is absolutely our reading of it, that it is possible the government would require a person to undertake ECT, or for that matter, other types of treatments that they don't wish to, simply so that they would be eligible. I'll also pass to my colleague, Jennifer Nixon, who is here too, in case she wants to add anything.
Thanks, Priscilla, and thanks, Senator. That is correct, and we have sought some additional information from the Justice Equity Centre as well, and they agreed with our thoughts that indeed may happen given how the legislation is currently drafted.
Okay. And are there other forms of treatment that you are concerned that the current legislation as written would allow a future government to make mandatory for those seeking access to the scheme who have psychosocial disability?
Yes, Senator. There are some interventional pharmaceuticals that would also pass the current legislation. I can provide their names on that as...
Okay. And for those that may not be familiar, what are the conditions currently for which electroshock therapy is recommended?
Okay. People are provided with ECT for persistent and long-term depression. And some people are provided it either voluntarily, or you can also be provided it, or given it involuntarily. But usually, yeah, so for long-term mental illness and psychosocial disability would usually deliver from that.
And in situations where somebody is not under one of the legal structures that then result in somebody undertaking a treatment that they don't consent to, because that is a whole area of Australian law that is, deeply problematic, but not specific to the NDIS. So in those situations where somebody may voluntarily be considering such a treatment, what are the kinds of things that they usually weigh up when considering if that course of action is right for them?
Usually the severe impacts of ECT, which can include short-term to long-term and enduring memory loss. That's the main concern with ECT. And
it's my understanding that those impacts are sometimes weighed by somebody considering the treatment, and they decide that that is a risk they're willing to take. That's correct. Some people voluntarily decide to undergo the treatment.
That is correct, Senator. But we would like to state that that's often on the advice of a clinical provider. Absolutely,
and that's exactly where I was going. So at the moment, it's a thing that you can decide to do if you feel it's right for you after having the advice of your trusted clinician or a professional. What you're saying to us, though, is something very different, which is the law as written could enable a government to require a participant with with what they consider to be a long-term psychosocial disability, anxiety or depression, for example, to demonstrate that they have undergone ECT before accessing the scheme.
That is correct, Senator. It is our understanding that if someone has long-term mental illness or mental health challenges that indicate for treatment with ECT under the way the current legislation is written. That could be one of the things they need to do before they get deemed permanent.